Hello, scholars. Today we will be discussing and introducing the court system. So we're going to be talking about the organization of the court system. We're going to be talking about something called judicial review, and we're going to be talking about what we call sort of judicial activism. And often you'll hear justices described as liberal or conservative, and we're going to talk about sort of what does that mean. Where does that come from? And also how sometimes that's not actually the best way to understand the judiciary. So let's get started. This PowerPoint is online. So if you want to follow along or just watch the screen, that will work just fine. So let's start with where does the law come from? When previously in third quarter, when we talked about law, we really discussed law as a statutory creation, essentially state and federal legislatures that craft criminal, family, or tort statutes that then, guide our lives. In addition, we've talked about with the presidency, especially, oftentimes Congress will create very vague laws, and that leaves it to bureaucrats or employees of the federal government and state governments to sort of fill in the blanks. And that oftentimes that can have the force of law as well. Right now, during this time of quarantine or social distancing, whatever we're calling it, this is an example, for instance, where the state of Oregon is giving bureaucrats such as myself direction on how to do, grading, and then we interpret those directions as a way of figuring out what does that actually look like. Courts or common law, this is what we'll be discussing mostly today. Common law is where the judges interpret statutes as well as follow previous rulings as a way of creating law that guides our actions. And lastly is constitutional law. Constitutional law is sort of uber law. It's the law that beats all the other laws. And we'll be talking about constitutional law in detail as we go on as well. So those are sort of the areas of law, but the area of law that I really want to talk about today is common law or judge-made law. And so I made up this sort of silly illustration to sort of illustrate how does common law, or what we call precedent, how does it work? So precedent works like this. Let's say Mr. Duden is walking down the road and he gets bit by an angry, German Shepherd. He sues the owner of the German Shepherd, and the German Shepherd said, "Hey, it's not my fault. I didn't bite you. Why am I responsible?" But the courts look at it and says, "No, the owners of a dog are responsible if that dog bites a person." And so the precedent from Duden versus owners of angry dog hold that the owners of a dog are responsible if a dog bites somebody. Now, maybe 6 months later, Mr. Isaac is walking down the road and he's bit by a Chihuahua. He would say, "Hey, my incident is similar enough to Duden versus owners of angry dog that in fact there should be the same outcome. The owners of the Chihuahua should also be held responsible." So let's say a year, 2 years, 3 years goes on. Mr. Moore is walking down the street. He gets bit by a dog, but in a somewhat unusual wrinkle, he was wearing these socks that he had made entirely of dog treats. And so the question becomes, well, is it a new question if you sort of are asking to get bit? And the court says yes, that if you're like teasing a dog or you're, wearing clothing made of dog treats, then maybe in fact you're responsible if you get bit, not the owner of the dog. So that establishes the case of Moore versus owners of hungry dog, where Moore versus owners of hungry dog say that if your own foolishness led you to get bit, then it's not the owners of the dog's fault. So then let's say 3 years, 4 years later, I, Mr. Koepping, am a butcher and I'm chopping up, pigs and cows and chickens. And at the end of the day, instead of washing up, I walk home, even though I have, chicken and pig blood and gore on me. A dog comes by, smells that I smell like, like a butcher shop, and bites me. In that case, I would sue saying that this case is like Duden versus owner of Angry Dog, and that the owner of the dog is responsible. Meanwhile, the owner of the dog would say, no, 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 this case is like Moore versus owners of Hungry Dog, and I am responsible. This is what lawyers do. What lawyers do is they say, this case, my case, is like these previous cases, and so I win. Whereas the other lawyers say, no, 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 this case is like these other cases, so I win. It's all reasoning by analogy. So this is how common law works. We look at previous cases and we figure out what's the most similar case to determine what the law should hold. Okay, so that's common law. Now, the court system that we have, there are federal cases and there are state cases. The state cases, and yeah, I know this is surprising, involve state law, and the federal cases involve federal law. Both systems, though, operate under federal constitutional law. So constitutional law, again, federal constitutional law, the US Constitution, it trumps all forms of law, right? It's the uber law. At both the federal level and the state level, here we have district courts and state trial courts. These are triers of fact, where they are going to, and we've already talked about, in trial courts, essentially the jury is going to, this is where you get your juries, and they are going to find out and figure out what happened because through the trial. And then the judge is going to explain the law, and the jury's job is to apply the facts of the case to the law to render a verdict. So that's the trial courts. These are the bottom level here that we see here. Now, in both of these cases, again, these are juries, one judge. Now, if there is an error in the law in the trial, this will then go to the appeals courts. So appeals courts, here you have US Court of Appeals or the state appellate courts. They have different names depending on the state you're in. These are going to be usually 3-judge panels, no juries. And the only thing they care about is the law correctly interpreted. What's important about the appellate system is it doesn't care whether or not you did it. What they care about is, was the law correctly interpreted? Now, if the appeals court makes an error in the interpretation of law, it could then appeal to the state Supreme Court, and Oregon has a Supreme Court of 7 elected judges. Or it can be appealed, if it's a federal matter, federal constitution, to the US Supreme Court. And there you have 9 judges that, as you know, are nominated by the president and confirmed by the Senate. So again, the key areas: trial courts, triers of fact; appellate courts, 3-judge panels, and they're looking at issues of law. Is the law correctly interpreted? And Supreme Courts, which are generally larger panels of more judges. And again, they are more interested in, is the law correctly interpreted? Each of these create precedent or common law for the lower courts. So the Oregon Supreme Court here, they're creating precedent that applies to the state appellate courts, Oregon appellate courts, and Oregon trial courts. The US Supreme Court, it creates precedent that applies for the entire nation, both Supreme Court, both state courts and federal courts. And that's why we pay so much attention to the US Supreme Court, because it has so much impact. It sets so much precedent. Now, partially one of the powers, well, not partially, one of the powers that comes from the judiciary is what we call judicial review. And appeals courts have the ability to nullify law if that law conflicts with state and federal constitutions. Remember, I told you that constitutions are sort of supreme law. So if a statutory law, an administrative law, even a lower court ruling, if any of those conflict with the Constitution, either the state constitution at the state level or the US Constitution at any level, then those actions are nullified. Now, sometimes this means very popular laws gets nullified. So one of the examples we can think of is a case called Texas v. Johnson, which said that basically flag burning is constitutionally protected. Now, flag burning is very, very unpopular. Most people don't like it. Most people would like it to be criminalized so that you could go to jail if you do it. But the US Supreme Court says, no, you can't do that. It's a violation of free speech to throw people in jail if they burn the flag. Now, this often makes for very controversial rulings. Great example of this, of course, would be Roe v. Wade, which said that abortion is a constitutional right. Now, there's a lot of people that very much disagreed with this. So when a popular law is struck or a controversial ruling is issued that strikes down a law that people like, they often accuse a judge of being an activist. Of being essentially politically biased or being anti-democratic because they're striking down a popular law. So often you'll hear courts or judges described as activists, and if you don't understand the context, it's sort of hard to understand what that means. But when I accuse a judge of being an activist, I'm usually accusing them of using their political bias to strike down a law that you think should still be intact. So if you hear the term activist, that's usually what it's referring to. Now, the U.S. Supreme Court has a number of protections that allow it to use judicial review to protect the rights of minorities and protect the rights of sort of the people. One of them, of course, is lifetime appointment. If you are a federal judge and a U.S. Supreme Court judge is a federal judge, you have a lifetime appointment, right? You cannot be fired. Now, you can be impeached by the U.S. House and Senate, but that's incredibly rare. So basically, if you become a federal judge, you have that job for life, which means you can issue unpopular rulings that make everybody super, super mad, but there's nothing that can be done. You get to keep your job, and the Congress can't lower your salary. So the idea is that that allows the judiciary to act independently. But at the same time, the judiciary is not explicitly political. So the judges don't say, well, because I'm a Democrat, I'm finding one way, or because I'm a Republican, I'm finding another. The judges argue that their decisions are based on reason, analysis, and principle. And so that is the justices don't identify themselves as political creatures. They certainly don't say, well, I'm a Republican or I'm a Democrat, so that's why I find this way. Instead, what they do is say, no, there's a reason for why I'm finding this way, and there's a reason for why I'm finding this other way. Okay, and this is why they write this out. It's called a decision. So while again, the justices do not explicitly identify themselves as political, a lot of the society does. So the US Supreme Court is not elected, but still many people characterize the justices either as liberal or conservative. This designation tends to come from who appointed them. So if you're appointed by a Republican, we tend to say that you're a conservative justice. If you're appointed by a Democrat, we tend to say you're a liberal justice. As well as if you subsequently, end up issuing a bunch of rulings that we deem to be liberal, then you can also be called a liberal justice or a conservative justice. So these are terms that are used by the general public, by the media, not really by the justices themselves. The justices themselves do not identify as liberal or conservative. And if you were to ask, a justice, are you a liberal or conservative? They'll actually get sort of upset about it. So when we call a justice a liberal, or the media calls a justice a liberal, what do we generally mean by that sort of broad characterization? Now, again, I'm not saying these are characterizations that are actually fair or accurate, but this is what they mean. So a liberal justice tends to believe in a broad protection of privacy. So this would be abortion or birth control rights as a way of extending privacy to basically personal decisions. They also tend to be interested in protecting groups that have historically discriminated against or marginalized. So equal pay rules, the support of affirmative action, protection of, say, gay marriage. They tend to be sympathetic of those accused of crimes. So they will be more interested in protecting the rights of the accused, less interested in, say, be more interested in striking down death penalty. For instance, the Oregon Supreme Court, which is a fairly liberal court, has shown a real hostility to the death penalty in Oregon law for a long time now. At the same time, they believe in an expansion in the government's role in regulating the economy. And they tend to believe that the Constitution is evolving, meaning that rights can emerge from the Constitution even if the words haven't changed. So, for instance, let's say Roe v. Wade, the right to an abortion. Um, Nowhere in the Constitution is a right to abortion described, and certainly none of the founding fathers discussed a right to an abortion in the original Constitution. But as time has gone on, liberal justices have believed that that right has emerged and established that right in the case called Roe v. Wade. As well, of course, liberal justices tend to be appointed by Democrats. Now, conservative justices, what does a conservative justice believe? Well, they tend to, because they believe in traditional values, or at least they believe that the Constitution doesn't establish new rights without amendment, they tend to be more comfortable with government intervention in things like birth control, abortion, and gay marriage. So those are areas where they're comfortable with the state regulating or banning. They are less comfortable or less concerned about the rights of those accused of crimes. They are, on a flip side, less comfortable with government intervention in the economy. So if you have a piece of property and you want to do something with it and the government doesn't want you to, they tend to be sympathetic to your rights as a property owner. They have what we call a stricter interpretation of the Constitution. Some people also call this originalism. And that means that the meaning of the Constitution doesn't change. So a right to an abortion doesn't exist in the Constitution unless you amend the Constitution, unless you actually change the words in the Constitution. That right to, say, abortion or birth control or gay marriage doesn't exist unless you actually change the text of the Constitution. Conservative judges tend to be appointed by Republicans. So let's go over these two things again because they're really sort of important to understand the nature of constitutionalism. The evolving standard, again, tends to be more associated with liberal judges. They believe that the Constitution evolves as the country does. So even if the words of the Constitution don't change, the meaning can, as we as a country sort of change with the times. So again, rights for LGBTQ. 200 years ago, the founding fathers would not have considered those. Today, we do, protecting gay marriage and striking down, well, just protecting gay marriage. Other rights that have emerged could be like a right to a birth control. Rights for, let's say, for instance, rulings that have banned the death penalty for juveniles when they've committed their crimes. The founding fathers would have never identified a right to not be executed as a juvenile, whereas in today's rulings we have. Now, strict constructionism means that the Constitution means what it says, or what the founders intended. So if you want new rights, you need to amend the document. And of course, there is a process for amending the Constitution. And that process did things like, establish voting rights for women or something like that. So the strict constructionists, they don't say that there can't be new rights. They just say that the way these rights should become about isn't through interpreting new rights, but through actually amending the Constitution through the democratic process. So let's look at who the current lineup of the justices are. Clarence Thomas is the oldest justice in terms of being on the court the longest. He was an appointee for the first Bush. He's generally more considered a conservative. Ruth Bader Ginsburg, Stephen Breyer, they're both Clinton appointees, thus considered liberal. John Roberts is the Chief Justice. He's also a Bush appointee, so is Samuel Alito. So both gentlemen are considered conservatives. Sonia Sotomayor, Ilona Kagan, they're both Obama appointees. And of course, Neil Gorsuch and Brett Kavanaugh, the two most recent appointees, they're both Trump appointees. If you're doing the math, there are 5 Republican nominees on the court and 4 Democratic nominees on the court. So sometimes you'll hear people describe this current court as a conservative court because there's 5 to 4. In addition, you'll sometimes hear it called the Roberts Court, and that's because John Roberts is the Chief Justice. So we often call a court by who the Chief Justice is, and the Chief Justice is sort of an administrative position. They do some of the other sort of administrative work that the other judges don't have to bother with. Now, there are some judges or some decisions in some areas of policy where the justices do seem to act along this liberal and conservative line. One of them is abortion. So if we look at Gonzalez versus Carhart, which allowed for a certain surgical procedure to be banned, a certain abortion procedure. If you look at the people who supported upholding that ban, they are Republican nominees. The people opposed are Democratic nominees. Affirmative action, a affirmative action policy in San Francisco or Seattle rather was struck with the conservative justices opposing the affirmative action policy and the liberal justices supporting it. Citizens United versus Federal Election Commission, which had to do with uh, can corporations and unions give unlimited support to a candidate, either support or opposition? Again, the conservative justices were united in saying yes. The liberal justices were united in saying no. And lastly, in the case of Salazar versus Buono, which has to do with can the federal government on federal property, can there be this large illuminated cross? Is that a violation of the Establishment Clause on federal property? The justices appointed by Republicans said that's fine. The justices appointed by Democrats said they're not. So there's some areas of policy where these understanding the court along sort of liberal conservative lines does seem to be a useful way of understanding the court. So affirmative action, abortion, religion, these are areas where that actually works. There's some areas that it doesn't. One of them is free speech. The court tends to be very, very supportive of free speech. So in Snyder v. Phelps, there was groups that would go to soldiers' funerals and chant and say horrible things. The court, both in an 8-1 ruling, so basically the bulk of the conservatives and the bulk of the liberals joined together to say that speech was protected. In another case, Safford versus Redding, strip searches were ruled unconstitutional in schools. And again, the liberals and the conservative justices joined together, with the exception of Thomas, to say that that was unacceptable, that schools can't do this. In another case, one of my favorites, Kylo versus United States, this is a really fun case. The question is, is it a search that requires a warrant for law enforcement to look into a house using heat-sensitive cameras, basically looking for marijuana grow operations? And in this case, some liberals and some conservatives joined up. So you've got Scalia, who's very conservative, and Ginsburg, who's very liberal, joining together to say, no, the government can't do that. But in another case, you've got Rehnquist and you've got Stevens, who say, no, that's fine. In a case that just happened, like 2 days ago, very interesting case about whether it requires all 12 jurors to convict somebody. Oregon was the only state in the union that only required 10 out of 12 people, 10 out of 12 jurors, to convict someone of a criminal charge. The Supreme Court said, no, you can't do that. From now on, you need 12 out of 12. But who the justices were pretty interesting. You've got the Trump appointees, Kavanaugh and Gorsuch, who join with much more liberal justices, Ginsburg and Sotomayor, in saying, yeah, you need 12 out of 12. Meanwhile, you've got Kagan, who's a liberal, and Alito and Roberts joining with the conservatives in saying, no, 10 out of 12 is fine. So Ramos versus Louisiana appears to be an area where, in fact, no, the liberal and conservative understanding of the justices doesn't actually describe how they're thinking. So in some areas, again, understanding the court according to a liberal conservative, sort of model of justices, that can be useful and sort of predictive. In other areas, it's not, and that's important to remember when we talk and think about the court. So I hope you've enjoyed our discussion today on the U.S. Supreme, basically the courts and the organization of the court system. Have a lovely day, and I will see you guys virtually.